the key for that side
Yeah,
of
we've
the
got
side
that.
too. So.
Not for pain, but,
Is it locked?
it's left, yeah.
My key's in there.
All our keys are.
I put a coat on
happens sometimes.
Sunday, and I'm like, I reached in the pocket of like a winter coat. I'm like, oh, here's my office key.
I had to go to a
I wonder where that was.
and I'd scratch it because it turned into a big bad infection. Started swelling up like all my lymph nodes are swelling.
Big lift off.
Oh, I was gonna say, no,
David?
David.
David?
We might need to go to Got Rare Birds doing their,
Yeah.
Y'all going now?
which we can go to, but she's like, Katie, she's going there afterwards. She's like, you're not gonna get a table.
Yeah, no, whatever.
Okay. We're about there.
Yes. We'll start in 1 minute. Is Shay coming? Do we know?
No, unfortunately, it's not.
Oh, Jerry.
No. No, he's working into it. It's only was here last. No, but I was. You know, it's one of those things. You just had a baby. And careful what you get instead.
I know, that's true.
Well, just on Thanksgiving.
I'm back. What's today's date?
19.
We're locked out.
Hold on a minute. I lost my land acknowledgement. Wait a minute.
Just one
Don't
open that door.
Yeah, and we're gonna spend some time up here with,
Should I wait till he gets back?
Yeah.
Okay.
I was just about to go.
how about you?
We're flying out on Thursday morning.
Yes, I'm trying to hide my ugly bandage.
You're fine. I didn't even notice anything.
Okay.
No, that's not too bad.
Yeah.
No,
Yeah,
I only have to
can't
keep it
wait.
on until tomorrow.
Nice. Thanksgiving with like dozens. I thought you were gonna say someone famous. That's maybe Joaquin.
There
Probably.
you go.
You wouldn't even recognize me.
Maybe. Yeah, right. What's that?
Over there. Jerry.
We have to wait for Mr. Winter to return.
We have to?
Yeah, we're all cooking.
19.
19?
19th of November. God, it's almost Thanksgiving.
I guess I haven't
Haven't
looked
even
at it
thought about
seriously in about 3 weeks, but
I'll tell you
I've been
later.
keeping an eye on it.
I'm imagining all kinds of things. I'm
Yeah.
imagining that Friends episode with the turkey.
Yeah.
Oh, God.
Yeah. Like, technically, you can go up to Union Street or down to Cass Street. And
So
if you circumvent the booths, you could go a little farther.
Public comment.
Oh.
So you may just want
But even though a person could claim they're staying in a navigable waterway,
Okay, that's fine.
I'd say
Okay.
the rule.
Hello, and welcome everyone to this study session of the Traverse City Planning Commission. Today's November 19th. Welcome everyone. Good to see everyone's smiling faces. We'll start first with our land acknowledgement. The land on which we gather is the territory of the Ottawa and Chippewa peoples who have stewarded this land throughout the generations. Thank you for your strength and resilience in protecting this land and inspiring us to uphold our responsibilities to do the same. Do we need to take roll?
I did visual roll call.
Okay. Yes, wonderful. I see that we have some members of the audience, and public comment was scheduled for the end. Do you all mind if we have it at the beginning before the study session begins? All right, great. So I'll be opening up for public comment if anybody has a comment to make. Okay, wonderful. Thank you. Okay, so today we're having a study session on board roles and responsibilities, and I'm turning this over to Mr. Winter to give a overview.
Yeah, thank you. We are joined today by two special guests. We have the city clerk, Benjamin Maritain, and the city attorney, Lauren Triblaut. Thank you. Did my best German pronunciation there. So today we're really focusing on commission training. So this is a presentation that Ben and Lauren did annually prior to COVID, but as you know, a lot of us fell out of cycle on things on COVID, but we're at a point where we have a lot of new planning commissioners, so we thought it'd be a great opportunity to revisit this. So Benjamin is going to start by kind of discussing parliamentary procedures, Robert rules, the order of meetings and things like that, and including your role. Lauren will get into the legal framework of planning, and then I will be covering planning fundamentals. So you will hear some topics discussed by both Lauren and I, but looking at them from different lenses. So please feel free as we go through this to ask questions. This is really intended for your benefit to better understand your roles within this body as well as the organization of the city as a whole. So with that, I will turn it over to Benjamin.
All right, thank you. Thanks for having me. I'm just kind of like channeling some of the energy from this picture. I'm a sailor, and it's just kind of like wishing I was out sailing. No offense. But yeah, I'm just going to kick things off, and please just jump in if you've got any questions. A lot of this stuff you probably are very familiar with, but it's just an opportunity, if you are familiar with it, to provide a refresher and also to provide space for any kind of conversation or discussion you want to have. And so I will just kick it off by saying, of course, the Planning Commission's role officially is to prepare and adopt physical plans for the city, review development proposals, both private and public, regarding their consistency with your official master plan, and of course also you review things in accordance with to make sure they're compliant with the zoning ordinance. So just speaking quickly regarding the role of the Planning Commission in relation to the City Commission, I'll talk a bit about Planning Commission and staff relationship, and then City Commission liaison, and then moving on more broadly, as Sean sort of mentioned, is I'll talk a bit about Freedom of Information Act, Open Meetings Act, boardmanship, media relations, and those types of things. And I don't plan on being very long. It might sound like it's going to be long. I don't think it will be. But the role of Planning Commission in relation to the City Commission is, of course, the Planning Commission makes recommendations to the City Commission, and the City Commission makes the final determination. And so, as you know, when it comes to amendments to a zoning ordinance, for instance, the Planning Commission can make a recommendation to the City Commission on, substantially what the topic is, and then it's up to the City Commission to take that recommendation or modify it, and they can modify it as they choose. Planning Commission and staff relationship, I share this with different boards sometimes, because I think sometimes when you have like the Planning Commission, a planning director, Parks and Recreation Commission, a parks director, the staff of course, is here to support and advise the different boards. Like, for instance, that's Sean's role with respect to the Planning Commission, but doesn't report to the Planning Commission. The planning director reports to the city manager. And some of this is also just for any public that's listening to. You're probably aware of this. But utilize your staff as a resource. That's what they're here for you. City Commission liaison, so Planning Commission is one of the boards, such as also Light and Power, for instance, that has a liaison to the City Commission. And ideally, the City Commission, of course, we've got two City Commissioners here that are the City Commission's liaison on the Planning Commission. And they're here to vote on things as a Planning Commissioner. And then when they get to the City Commission, they vote on things as a City Commissioner, sort of wearing two different hats at two different phases. And they're here to represent their constituents and the way that they feel best represents those constituents. And also, it's an opportunity with these liaison relationships to have two-way communication. And I will say that we haven't for a few years. Is probably something that we might talk about tomorrow night with governance, with the City Commissioner. Maybe it'll be later, as we used to have periodic updates from board and committee representatives at City Commission meetings. Not meant to be something formal or exhaustive, but just a way to keep that communication flowing. And so I wanted to mention that. Moving along, just with respect to boardmanship, so this is really sort of how you work together as a team and as a board. And when I say team, that doesn't mean that everyone has to agree, of course. It's healthy that you don't agree on everything. But, there are certain standards that we recommend that you follow. Of course, addressing everyone professionally. Nothing should be personal. It's talking about the issues that you're facing and working with. Speaking slowly and distinctly so everyone can understand where you're coming from, as well as the public when you're deliberating and discussing matters before you. And then, of course, the responsibility to ask clarifying questions. If something's not clear to you Or if you think it might not be clear to somebody listening or interested in your business that you're conducting on behalf of the public, please ask clarifying questions. It's really important. Of course, also review your meeting packet. I don't know routinely how thick planning commission packets are. I know city commission, which I'm a lot more familiar with, sometimes there's several hundred pages. So you have to kind of choose what you're really going to zoom in on, but work to review your packet as much as you can so that you're as prepared as possible. Ask questions of staff in advance where possible, or give them a clue that maybe you're going to have some questions. Sometimes those questions don't occur to you, though, until you're in the meeting. That's just the reality. So when I make that recommendation, it's not to stifle on-the-spot thinking and conversation. Recognize, of course, that the commission only speaks as a body, so through the actions that the planning commission takes. So if you're out addressing a topic, say the media gets in touch with you, or it's a member of the public, or any constituent for that matter, you don't want to represent that you're speaking on behalf of the planning commission. You can be speaking as an individual planning commissioner. We already talked, yeah. If somebody
You go
has
first,
something.
Shaw.
No, I was just going to say, to Ben's point about asking clarifying questions, you have your role here at the meeting, but you also have that role out in the community too. So you will often be asked by people who know you're on the planning commission questions. So that helps you better serve yourself or serve that role outside of this room by just being informed. So don't ever be shy about those questions if you need them.
My question was, on boards that I've been on in the past, we've had an ethics policy. I'm just dabbling in the idea of that for city or planning. I think the rules are a little different because these are elected and appointed boards. The other boards that I was on were like for nonprofit boards.
Sure.
But we adhered to those. They helped us guide moments of discourse when board members didn't get along, or if a board member was doing something that went against the benefit of the board. Could you speak to your knowledge of that, if that's common in municipalities?
It is fairly common. We don't have an ethics policy at the city. I think it's something that we should explore. And because it's good for a whole host of reasons. It just sets the standard, and then everybody sort of has an understanding of what the expectations are. And it drives up public trust, too. So I think it's a great idea and something that we should work on.
Cool. Thank you.
Yeah, absolutely. All right, moving on to media relations. We have a former member of the media on your planning commission, Mr. McGillivray. The media, and I say this with complete sincerity, plays such an important role. I've often said that I consider them the fourth branch of government. They help hold people accountable. I think that that's a good thing. They help inform the public and allow for more full participation, and there's a lot of value to that. But of course, remembering when relating or interacting with the media, you also have a responsibility to help them do their job and to also make sure that information is clear. So recognize and respect that important role that the media plays. In an instance of a crisis, I don't know, hopefully the Planning Commission doesn't deal with actual crises, but in an instance of where something seems really urgent, where maybe you don't have a response, just have what I consider a holding statement, which is just really saying something like, I know that this is important and I don't have the answers, but I want to make sure you get the correct answers, and let me have the planning director or whoever get back with you, or refer them to a member of staff. But don't ever feel the pressure to speak about something that you don't feel knowledgeable on. And I just like being transparent, saying, I honestly don't know. Let us get back with you, or let me get back to you. And if it's not your expertise, like I sort of already said this, but you don't feel you can knowledgeably comment, refer it to someone else so that we're not confusing folks. And remember, I think sometimes, because Traverse City is, it's not a huge community, and I think sometimes we feel like we know each other. This is fairly casual, and you might be humble about it, but know that what you say reflects on the image of the city. So when you're speaking, it's important to speak with that in mind. Your words do carry weight. You might think, it's just me. I'm just kind of making a statement, or I'm just commenting, but your words and what you say and how you say them affects the image and reputation
Yeah,
of
and
the city. Don't you have
I just-
something, Sean?
If you are asked, because sometimes if the media is here, they might hear something that you said during the meeting and they want to talk to you afterwards about it. And it can be very intimidating if you're not used to it, but having done it a lot, they might take 5 minutes of video asking you questions, but they typically take the best 5 seconds of you and put it in the news clip. So just know that the media isn't trying to make you look bad, they do want to convey the story more than anything. And to Benjamin's point, we do have those small town connections, but our media is, distributing to all of Northwest Michigan. So you're representing Traverse City to all of Northwest Michigan when you interact with the media.
But I want to point out where it says the chair is the primary spokesperson with the media.
Right.
That's in our bylaws, I believe.
Okay, okay, great. And I have some cogs on the wheel here, but I'll just say, be real, be concise. And I like to emphasize being real because it's sometimes I think if you're not used to speaking with the media or in front of a group, you can feel really like a lot of pressure and you have to say things just ever so perfectly. And it's just good to show the authentic side of government. I think that's important. And of course, always be honest. And then moving along, this is sort of more of the parliamentary sort of stuff of what I wanted to share. So motions, any member of the board that wants to make a motion just indicates I move, and then you state the motion. I know in your packets there's typically pre-prepared suggested motions to help you. You can vary from those motions as long as it's within the legal framework and you've got staff here to help you. All you really need to do is say, hey, this is what I want to do. Help me put it in the form of a motion. That's their job to help you with that. Any motion made requires a second. Motions can be withdrawn. Motions can be amended. So if a motion's on the table and there's a desire to amend that motion, someone, it doesn't have to be someone who moved or seconded that original motion, can make a motion to amend. That gets seconded. If it passes by a 2/3 vote, then the motion is amended and you have the new motion before you. And I know with City Commission, we always try to say, okay, this is what you're voting on. So if you vote yes on this, it's going to change the motion in this fashion. And then now's the new motion before you. Comments should not really be addressed to the audience. So if you're up here deliberating, conducting the public's business, and so you really want to keep comments up here in front of the Planning Commission, that's not to say that if you have someone give public comment and there's a simple response to give that it might make sense to do during the meeting that you do that, but you really don't want to get into a back and forth. And just remember that the chair presides over public comment, and any ruling of the chair can be overruled. So no one is king in this castle. So any time the chair makes a ruling, there can be a motion to overrule that ruling, and that's your prerogative. And I already mentioned that staff will assist with motions. And then for your regular and special meetings, that's where you take action on items. And if you want something done, I recommend that you memorialize it in an action. Or say, this is the consensus of the commission, and you ask that that be reflected in the minutes so that there's something formal on the record, and that therefore that's documented. And then at study sessions, there can be a consensus. You're not taking action, but it could be a consensus to bring an item back for action. We've talked about this, and now it's a consensus of the board to ask the planning director to do X, for instance.
I have 2 questions.
Okay.
I know the answer, but I just want to ask it officially.
Yeah.
If there's no second to a motion, you can just let it die, right?
Yes.
Okay.
Yep.
And then the other question is calling to question. So that is not something I've utilized before. I know it exists. Is it for, I just want to get a little more information on it. Is it for, does it have to be for an agenda item? Or can it be like, sometimes on planning, we get really into the weeds about something. It started off as an agenda item, and then we're like 5 sub-bullet points in on something, and
Okay.
we've latched, and we can't let go.
Yeah.
Before a motion's been made, you mean?
Yes,
Yeah.
during deliberation or discussion, before public comment, before a motion. can you call to question that, or does it have to be after, while you're deliberating a motion?
It has to be while you're deliberating a motion. There needs to be a motion and a second. A motion on the floor means there's a mover and a seconder. And by the way, movers and seconders don't have to vote in favor of the motion. That's something that's commonly misunderstood. And so really, when you make a motion to call the question, it's after a motion is on the table, as I said, and it's after there has been an opportunity for every member to participate in the debate, reasonably speaking. And then there can be a motion to close the debate. And then if that passes, and for the Planning Commission, it requires 5 votes because it's a 9-member board, and that passes, then you're compelled to vote on the motion in front of you. I should mention that I don't know what your rules say or your bylaws about public comment, if that's during each agenda item, but, okay. Legally, you're required to have public comment at least once during a meeting, and you have to provide an opportunity for everyone to speak. So you could say, we're going to limit, if you had a ton of people, you might say we're going to limit public comment to 3 minutes each. But you can't say we're limiting public comment to 30 minutes total because we got to get out of here. That might mean not everyone had an opportunity to speak, and that's not okay.
Benjamin, can you address maybe or maybe Lauren too, the line between free speech and inappropriate speech, public comment?
Yeah, I can boil it down.
Yeah.
You want to tell? Okay, all right, okay. So really, people can say just about anything they want to at a public meeting, unless it's words to incite violence or it's truly profane speech, right? And so when we say words to incite violence, it's not just like something like, it would be something along the lines of, and we've sadly had this happen. It's been quite a while at a city commission meeting, but where a member of the public said, your addresses are all online and I hope something happens to you and your families. That is not okay. And I let that individual know very assertively that they had crossed the line, and I'm not trying to get heavy, but I'm just giving you an example. That's completely unacceptable to say something that might incite violence. And the other is true profanity, something that would offend a reasonable person, not someone waiting to be offended.
And usually what we would recommend is you just adjourn the meeting at that point. If a person's not gonna get it together, you say, okay, we're gonna adjourn the meeting for half an hour.
You mean recess,
Yeah.
right? Yeah, yeah.
And usually that takes care of it. People can settle down when they take a break, and everyone can take a break and let it chill out a little bit.
And I
And
do-
So,
Go ahead.
nope, you go ahead, you went.
Well, okay, so, and I think you say this at the city commission, and we say it here, that we ask that people be respectful.
Mhm, yes.
So that's not profane.
Right.
That's not threat.
And you're only
but
asking it. You
we're
can't
asking
require
it,
them to be
But
respectful.
okay, so if they're not being, like they're going up here, coming up here, which has happened, saying you should be ashamed of yourselves, that kind of thing, and you start really feeling it.
Right.
I think, and I want to make sure that it's okay to say, we have asked, please be respectful.
You can-
Not cut them off,
Right.
but say, please be respectful.
Yes,
Just
yes.
throw that back out there.
But be very careful and judicious, like
Yeah.
where you truly think it's not being respectful. Because I know as public, people who are in the public space, your work gets attacked sometimes and questioned heavily, and that is okay. Like it doesn't always feel the best. So I just say some people are a little too quick to say, please be respectful. So just be careful about that.
And when it's personal attacks, though, I think it's okay to.
Yes.
Okay,
Yeah.
all right.
And
Okay,
go ahead,
No, no.
please.
No, go ahead.
Oh, I just was going to say, I do think it's really important if you have, and the Planning Commission deals with some stuff that's really emotional for folks. It's their personal property. And the City Commission certainly does too. And when we have a lot of people who are going to speak, something that we like to say is that we want an atmosphere that's comfortable for everyone. So we ask that there be no reactions to comments given, because you don't want a bunch of people applauding
Right.
something, and it makes somebody else with an opposing view feel like, I can't get up there. The goal here is to make everyone feel comfortable speaking. Mitchell?
Yes. in the interest of having everybody heard, but planning commission, also city commission, generally have, say, a 2 to 3 hour meeting. But sometimes a particular issue can bring out a whole lot of people that want to speak on that issue, such that you can have a couple hours. I haven't seen it here, but in other municipalities, 5 hours or more of just public comment. So what procedures are there that would still allow a meeting to happen, or for some of the agenda items that had been scheduled for that meeting to be put off to a future date?
I think, if there's items that if you were overwhelmed and there's so many people who want to speak, then you could take a look at what items you're going to take off the agenda. You just have to evaluate what makes sense. I can't give you a black and white answer, but it's an evaluation of what's on the agenda at the time and what makes sense. And I mean, I have never seen, I mean, we've had city commission meetings go very late, past midnight. It's not often, but it has happened. We've still given everybody a chance to speak. I mean, that is your role, is to give an opportunity for everybody to speak. And some boards allow folks to comment during or at every agenda item. That is not required, but it is a more inclusive way to provide for public comment. And I think that as public representatives, it's our role to provide for that. Did I answer your question enough?
Yes.
Okay, all right,
But
great.
before you go on, I do want to point out for anybody watching, this bullet, that the comments should not be addressed to the audience, because a lot of times, people wonder, why are you not responding to me? And they think we sit here like cold stones, not responding, and it's because we're not supposed to. I mean, unless it's a real quick, like you said, a very quick answer. So I just wanted to point that out for anybody watching, that any of these boards, city commission, DDA board, us, we're kind of trained that you don't get into a back and forth, and it's not that we're not listening intently if we don't comment back.
Right. And I think sometimes it's good to just say that.
Yeah.
And then to say, oh, I know, this individual just got up and spoke, and I'm going to ask Mr. Winter, or I'm sure he's going to talk to you afterwards. Or I can talk to you as a board member, I'll catch you afterwards, sort of a thing. But it's, if you want more of a mingly type of a meeting, then you want to arrange a town hall, and sometimes
Yeah,
we do
right,
those.
yeah, right,
Yep.
right,
Yep.
exactly.
Or open houses, we do a lot of
Yeah.
those, so.
Right.
And the other thing with the comments should not be addressed to the audience bullet point, I think, is speaking to, when someone's at the podium, they're supposed to be speaking to the commission, not to other audience members. Because, and again, this is a meeting of the commission that the public gets to watch, as opposed to a town hall or an open house where you're more interactive with the public.
It can also fire people up and get things a little out of control. If it's like, hey, this person just said this, and I think they're, they don't know what they're talking about, and they might say it in very different words, and then it turns into a thing. And so, we always say, please direct your comments to the board up here.
And I've seen times where chairs have, if there's like a big crowd, they've encouraged people, like, if what you want to say has been spoken, you can just say, I support this because of what has been said, and it will have the same meaning. That helps people realize, like, I don't have to reiterate everything that's been said already for my comment to matter to you.
My only thing, sorry. I don't know, yeah.
I was just going to say that just because we don't respond to someone's comments when they're making them, because it's their time to speak, doesn't mean after public comment is over, we can address, and we often do address, some of the points they've raised and explain. And sometimes those points they've changed my mind. There are things I hadn't considered, and we bring them back, or maybe we hadn't considered. So, public comment has value, but it's not a debate.
And sometimes you'll get people here at public comment because they have a question on something not even on your agenda, but they don't know where else to go. So they might pose that question. And sometimes just talking to them afterwards to direct them to the right resource is really what they need in that moment, So we are all sitting at this table probably a lot more well-versed in how this operates than most people, unfortunately.
So back to the respectful thing, real quick.
Yeah.
I've been called a name on the record before by a member of the public. I didn't really catch it in the meeting, in the moment. I felt it was a threatening name. We definitely caught it on replay, and staff were talking about it for a day or two.
Okay.
What does that look like? Because I think it would be different if you caught it in the moment where you could address it. Yeah, just kind of playing that over, because I would have felt threatened if I actually was cognizant of the term in the moment, but I didn't hear it until I was told about it later.
Well, I don't know the specifics of exactly what you're talking. I mean, I get the general picture you're painting. I think that, if there's someone on the board that has a relationship with that person where they feel like they could reach out to them and just sort of say, hey, but I would also be a little careful about calling people after that. That's my gut. Is like, you don't want to make it seem like you're calling someone up and trying to intimidate them from coming to a meeting. So it would be better if it were addressed during the meeting. In this case, it wasn't noticed. But I would be cautious about calling people after the fact.
Yeah, and I didn't have a connection to the person, so I didn't know. I think maybe somebody knew somebody, but I don't think it was ever addressed.
Yeah, and if I remember, it wasn't a comment during public comment at the podium, it was a comment shouted from
Correct.
the crowd. So
Oh.
like,
Yeah.
if, it didn't amplify on the sound, so if you
Correct.
weren't over there, you didn't hear it.
Which is why it was
Okay.
picked up later,
Yeah.
and like I partially heard it, but not fully.
I think that's one of those times whereas, I mean, it can be unfortunate, but some of that stuff you have to try to let roll off your back. Yeah.
Thank you.
Yeah. All right. Open Meetings Act. I'll be kind of quick about this. I think you're all rather familiar with the Open Meetings Act, but it's an important law that endeavors to ensure transparency in public business, where anytime there's a quorum of a public body, and that's always more than half. So this is a 9-member board, so 5 or more of you gathered as a quorum. If you have a subcommittee, I don't think the Planning Commission has a lot of subcommittees, but if you do, it's whatever is more than half of that number. So City Commission occasionally has 3-member subcommittees, and we try to really drive home, like I know you as city commissioners, you're used to knowing that you can talk to, 2 other of your colleagues, because that's less than a quorum. But if it's a 3-member committee, you can't talk to even one other member of that committee outside of a properly posted, conducted in public and at a public place meeting. So any quorum of a public body can't meet any sooner than 18 hours after that a notice has been posted online in our case, and also physically out front. And we talked about public comment and what's required there. We've talked a little bit about the public having a right to observe but not deliberate. Closed sessions, the Planning Commission is legally allowed to go into closed session. There's provisions and criteria for going into closed session. You can't go into closed session just because you want to. And the Planning Commission, the one that would most likely come into play, although I know this board doesn't go into closed session very often, would be to review the contents of an attorney-client communication. City Commission has some more frequent reasons, like trial and settlement strategy, union negotiations, evaluating their employees that report to them if requested by that employee.
Is real estate transactions?
Yes.
Can be, yep.
Yep. And then, so that's the Open Meetings Act, essentially. And then Freedom of Information Act, any document or communication you receive in your capacity or send in your capacity as a member of a public body is subject to the Freedom of Information Act, regardless of the manner in which you receive that document. So if it's a text message, if it's an email to your personal email or to your city email, it's a public record. And so any time we receive a FOIA request, my office serves as the FOIA, me officially, but my office as the FOIA coordinator for the city. we will let you know, this is the FOIA we've received. We've got 5 days to respond to that. And, we do have legally required turnaround time. We can't just say we don't want to provide that because it's difficult or it's uncomfortable or what have you. So just know anything you're putting in writing in any fashion is subject to public disclosure, and same thing with anything that you receive. Any questions on that? Okay.
I liked what Ben would often say at the city candidate tour orientation is like, just remember what you put in your email. If you're not comfortable with it being on the front page of the paper, then don't put it in an email, because that's how it works. So.
No, so Katie was asking me to speak to if emails can be deleted. So you're required to keep public records for a period of time as specified by our records retention policy. And so I would say, generally speaking, just know you shouldn't delete any email at a minimum less than until it's at least 2 years old. And if you have a reason to keep it for longer than that, that's up to you. But if you do have it and a FOIA request comes in, you cannot delete it because it's beyond that retention period. It has to be disclosed. And then if you've ever got questions about records retention requirements beyond that, just reach out. But the general rule of thumb is a minimum of 2 years. It's longer for city commission in some instances. All right, I think that's all that I have for the group, unless you've got any general questions for me. Otherwise, I'll stick around in case there's something that pops up. All right.
Well, maybe I should consider deleting some old emails, because I think my emails go back till like day one here, and I never.
6 years ago.
Yeah, 6 years ago. That's a lot of emails.
Well, you can always archive them.
Yeah,
Or swipe left.
yeah, I can do that. That would
I'm
work.
kind of an email pack rat. I like the information, but
Because
if
then
you
it's
have it,
there
you have
and
to
you can
provide it.
search and,
Yeah,
yeah, it's,
right.
yeah.
Right, I think it's
Is
turned
it
over to
me?
you,
Am-
Lauren, now, right?
I'm up, okay. So it's nice to see some faces. I haven't met everybody on the planning commission yet, so, or I just recently met them and see some old faces too that I've known for a long time, so thanks for having us. I'm gonna go through a few, things about conflicts and then kind of get into some of the, standards of review for different decisions that the planning commission, might make. And so we'll go from there. So conflicts of interest is something that I always go over with the city commission. It's something important when you are on a board. You have to kind of think of all of the other boards and things that are going on in your life that you participate in. And this is up to you because we can't keep track of all of those things. We don't know what you're up to when you're not here with us. And some of these apply more to the city commission because the planning commission typically isn't entering into contracts and things like that, but I'll just go over them anyway quickly. So contractual conflicts of interest, that's a state statute and it provides that a commissioner generally cannot be in a contract with the municipality. So this would rarely apply to the planning commission, but just something to keep in mind. Financial conflicts of interest, obviously you can't financially benefit from any of the decisions that you're making as a planning commissioner, so that one is pretty straightforward too. And then there's a judicial doctrine called the appearance of a conflict. And that's not a law in the books, but this is something that judges have created through decisions that they've made. And really what it speaks to is the confidence that the public has in the decisions that you're making. So if there's some sort of relationship that you might have that would call into question whether you can be impartial in the decisions that you're making, then that's something that you shouldn't be participating in. So I like to say it's sort of like, think of your family connections. If, your mother, father, husband, wife, son or daughter is coming before the planning commission and asking for an approval or something like that, that could be an appearance of a conflict. If your 27th cousin twice removed is coming before the planning commission and asking for some kind of an approval, that might not be. And it's sort of a gray area, but, I'm always around if you want to come and talk about conflicts. At the end of the day, conflicts, the commissioner decides whether there's a conflict, not me, not Ben, not Sean, not any of us. But I'm happy to talk that through with any of you and kind of hash it out and help you come to that decision. Generally, the resolution of a conflict would be to recuse yourself, so disclose what the conflict is, and then recuse yourself from the vote. And by recusing, I mean leave the room. So you don't want to sit up at the dais while everybody is debating and, give them the stink eye, and then try to say, well, I recuse myself because I didn't vote. You really want to just leave the room, let the agenda item play out until it's been voted on. Someone will come get you, and then there's no question that you didn't participate in that whole process. So, okay. Incompatible offices, that's another one that's a state law that you sometimes have to think about. And it mandates that a public officer, which is what you are when you're a planning commissioner, can't hold 2 or more offices that are incompatible with each other. There are some exceptions to this, so if you ever think you have one, again, just come talk to me and we can figure that out. They're kind of specific or obscure. But an incompatible office is defined as an office that is a subordinate, one subordinate to the other, one supervises the other, or there would be a breach of duty if you were holding both of the offices at the same time. So an example of this would be if you sit on a different board that the city commission appoints that board. So I'm saying for a city commissioner, you can't appoint your own boss, right? You can't. So that would be an incompatible office because one would be subordinate to the other. I don't know how often that would really come into play for the planning commission, but again, something to think about. I know there's a lot of folks that wear a lot of hats, so.
Yeah, and sometimes it's not intentional. A lot of small
Right.
communities are just trying to get by with the staff that they have. But I did some work when I was consulting for a village where the village manager was also the zoning administrator and also a voting member of the planning commission. So he would court businesses, review their plan, and then vote to approve it. And that was shocking.
It's a little strange.
It's a little strange, yeah, that allowed to happen.
Yeah.
And we grew up there, Jess, so. Not surprising, right?
But, so we couldn't have Sean Winter as a planning staff member also be a member of the public on the planning commission. But if we had, say, planning department staff for an adjacent township that happened to reside in the city of Traverse City, they could serve on the planning commission.
Correct.
So all of those things that you mentioned, I'm not going to list them back, but like the conflicts and all of the things that we just talked about, could those be referenced in an ethics policy?
Absolutely.
Okay. So that way there's then like a doctrine that you could be held to, because as of right now, they would just be held against like the law and that.
Well, so
And our
there-
bylaws.
Yeah.
We do
Okay.
speak to
Oh,
it in
and
our
the bylaw,
bylaws.
yeah. And there are different consequences for different conflicts of interest. So it depends on which statute or rule you're falling under. It could be just that your vote would be removed from the tally. But if it was a close vote, that could make a difference. It could be that you could lose your seat on the planning commission. It just depends on the situation. So best disclose and recuse. One other thing that I just want to touch on, and this does come up sometimes with the planning commission, is, well, 2 things. You have a duty to vote in the absence of a conflict. So I think we've heard a lot of things already this evening, like, the public service is not for the faint of heart, right? You have to sit up here and listen to people that are unhappy, and you're never going to make everyone happy. And you can't just say, this is really hard and uncomfortable, and I'm just going to recuse myself because it's icky and I don't want to do it. You have to vote unless you have a conflict. So if you have a conflict, disclose it, don't vote. But if you don't have a conflict, take a deep breath and just vote anyway, even if it doesn't always feel nice. Ex parte communications, this is something that does come up with the planning commission sometimes, because you have folks, property owners, coming before you and asking for a recommendation to the city commission or even an approval, like on a site plan. And so a lot of times what folks will try to do, and I think this is human nature, is they'll call each and every one of you and they'll say, hey, I've got something on your agenda in the next meeting, and I just want to have coffee, tell you about my project. And that's an ex parte communication. So it's outside of the public meeting. And what really you want to think about is, the point of the meeting is that you get all the same information as a board at the same time. You know what you heard. All of you heard it at the same time. You heard the same thing, right? And the public gets to watch you do that too, and then deliberate about it. So it's really not a good idea when you've got something coming up on an agenda, and you know that that's coming up on an agenda, to, go have coffee with the developer or the property owner. And, I know you want to be prepared, but we want you to have all the information together. And so then we don't have this whole discourse about, well, we don't know what that conversation was, right? Because it happened outside of a public meeting, and maybe one commissioner got told something different than another commissioner, and that's really going to throw a wrench into the process and into the public trust of the process as well. So really recommend against that. Okay, so a little bit, I'm going to go ahead, Mitch.
But we could say visit the site without meeting with the developer, just to see what it actually looks like on the ground and how it fits in with the surrounding neighborhood context.
Sure. I mean, I think you can do that. I think, there's even been times when the whole planning commission has taken a field trip.
Yeah, we can
And gone
arrange
it-
those,
yeah.
and we would have a quorum then, but since we're not discussing business, we just notice it appropriately
post
that,
it.
a quorum may be present, no topics will be discussed or decisions made and stuff.
Right.
So that's how we cover ourselves legally from
Sure.
that and still accommodate your needs.
So, I mean, I think that would be even better if you got a particularly tricky, development or request coming to you, and you think that you really need to see it. You really need to go out there and look at it to understand it, and make the most informed decision that you can. I mean, bring that to staff and say, at a meeting, I think, even if you're, I think we really need to all go out there and look at it, and we can help you make that happen.
Maybe for like a SLUP or a PUD or something large that requires the extensive review.
Sure.
But please don't trespass. Let's get permission
Oh,
first.
right.
Yeah, that's
Oh,
the one
right.
thing I do want to say.
That's
'cause
true.
that-
Thanks,
you
Sean.
just can't go walk on people's property.
That's
We have to
true.
get permission
Yeah.
from them.
Okay. So a little bit, I'm not going to go way back, but zoning and planning as a legal kind of theory, it grew out of nuisance law. So before we had zoning and planning acts, really what we had was a reactionary way to be able to deal with land use decisions. And really, it had to reach a level of something that was dangerous to the health, safety, and welfare of the public, or really hazardous, and then we could react and regulate it. So what grew out of that in the early 1900s was the idea of zoning to get ahead of that, so that we could have regulations in advance and anticipate what folks might be doing as far as land use, and try and head off some of those issues that might end up being a nuisance. I mean, this has evolved even so that we can talk about aesthetics in zoning, and that might even be enough of a reason to regulate something. But zoning is a very specialized police power, and what it really tries to do is balance the public interest in regulating these nuisance type of issues with private property interests. And that's why we have a very specific process whereby we can enact zoning ordinances. And we can only use that process, and that is to protect people's due process and interest in their property rights. So it kind of helps to understand how that grew as a body of law, to understand really what your role is in what you're trying to do, and what that balance is between private interest and public interest in zoning and planning. So what we have now is the Planning Enabling Act and the Zoning Enabling Act that gives us that structure and process for bringing these ordinances into existence. So when decisions are made, they can then, of course, be challenged and appealed. And so I want to talk a little bit about that, and it helps, I think, to understand what the standard is that a judge or another body will judge your decisions against, so that you can know when you're making those decisions how to kind of lay them out correctly so that they would withstand a challenge. So who might review, a decision that you make? It could be the Board of Zoning Appeals. It could be the City Commission. It could be the Circuit Court. It depends on what the decision was and how it's laid out in the ordinance. Special land use and PUD decisions can go to the Board of Zoning Appeals if that's what the ordinance says. Ours doesn't. So those decisions, if made, would go straight to Circuit Court. And then review of administrative or quasi-judicial decisions can go to the Circuit Court as well. And the general rule is in the Michigan Constitution, and then there are kind of variations to the rule. So the general rule is that you have to have a minimum that the decision is authorized by law, and that if there's a hearing required, the hearing was there was proper procedure for the hearing, and that the decision was supported by competent and material evidence in the record. So I might be getting a little legalese, so forgive me. So the review, when I talk about the record, is limited to the record. What a circuit court, I'll take an example. If we have like a special land use permit that is approved, the record would be everything that was available, that was in your packet, and that may have been presented at the hearing, the public hearing, and anything that was sent to the Planning Commission for that hearing. So maybe emails that the public sent and things like that. That record would go to the City Commission and would be added to whatever they saw, and then they make their decision. If it ended up going to Circuit Court, the judge cannot add to the record. That's what they've got. And then the review of what the decision was, the judge doesn't get to look at the whole record and say, I like this decision or I don't like this decision, and I'm going to just change it because I think a different decision could have been made. The rule is, if there was evidence, competent and material evidence in the record for the decision that was made, then it will be upheld. So really what you need to think about is whether you're going to say yes or whether you're going to say no. Either way, there has to be material evidence, competent material evidence for either decision. Does that make sense?
So,
Yeah.
so to reiterate, like if someone appeals something to the circuit court, the judge isn't going to look at the standards and say, well, you said the standard is met, but I don't think it was met.
Right.
Typically, they're going to make sure you followed proper procedure. It's still your authority to arrive at a conclusion, but that procedure has to be met, and that's what they look at. And they can get really sticky sometimes. We were at the planning conference this year, and the legal session that we all attend, they were talking about SLUPs, and they talked about an example from Traverse City from 2016 on a 10-story building. And one of the things that the judge threw out was there was a standard whether or not it would add a burden to emergency services, whatever the development was, that 10-story building in that case. And it was reported by staff that, the police department reviewed this and determined not. The judge flagged that because they're like, well, did that person who responded have authority? Was it the police chief? Like, it was that degree of specificity, but not the decision of what the police said, but just how it was documented in the material
record.
And so those are those nuances that we try to navigate for you in what we present to you.
Right.
But I'm sorry, Lauren, if it had been like, this person reviewed it, this was their exact conclusion, that would have been better? Or would it have been better to have not had that in the record?
Well, you would have to have something, so if the requirement of the ordinance is that it can't be a burden, then you have to have something in the record that says,
Somebody reviewed.
yes, it's a burden, or no, it's not a burden. And then you would have to have something that says why.
Okay.
So you would have to have a document in the record that lays out the reasoning why. And to go a step further, when we're talking about this substantial evidence test, that's embedded into competent material evidence. It's really what a reasonable person would accept as a sufficient amount of evidence. It's called more than a preponderance and less than a scintilla. So, judges make up these things and they say them and they become our tests. It's not it's not a criminal standard, right? So when you think about like beyond a reasonable doubt, if you're going to be criminally liable, it's much less than that. But it's more than a scintilla means like a grain of sand, right?
Has to be enough.
So it has to be enough that a reasonable person would look at it and say, okay, I might not agree with that, but that's an amount of evidence. That's something. It's more than just a grain of sand. So, and Sean's right. It can be very tricky and it can be very technical. And so that's why really, that's why staff tries to go through when you have that kind of a decision to make every single subsection of the ordinance, and you'll see in the staff report they'll be filling in underneath that standard. These are all the facts, and you can choose from the facts which ones you're relying on. That's your job, right? And say, yeah, the standard's met, and these are the facts that are in the record, and that's why we think it's met. Or you can say, no, it's not met, and these are the facts in the record that make us think it's not met. But either way, it has to be supported because it can be appealed by the applicant if it gets denied, and they can say, you denied it, but there wasn't anything in the record for you to deny it. Or it can be appealed by somebody else that says you granted this and you shouldn't have, there wasn't enough in the record. So really, it doesn't matter, either way. If you're going to say yes or say no, what really matters is that you have each and every standard supported with evidence. So, and we're here to help with that. Not always, successful, but yeah.
It's kind of like you can't prevent someone from suing you,
No.
right? But you try to mitigate your risk and your liability through your actions. So that's really what we try to do too. And we try, like I said, to help. We don't get many SLUPs and PUDs the way our ordinance is structured, but we will send a form to each of the appropriate staff personnel to fill out with their name and to respond to some of those so that we can add it to the record. And so that's the background work that we do for you guys.
Right, and so that we can bring that information to you so that you're informed when you're making those choices. Right, because you're not expected to be the police chief or the city engineer. I mean, that's right, you have to rely on those folks to give you that information.
And there are likely established appeals timelines, right? Like for a SLUP, you have to appeal within
Oh,
X
yeah.
amount of days
Yep.
of,
Yep. So another example, site plan review. So some things you can deny or approve. Some things you can deny, approve, or approve with conditions. Okay, so when you're thinking about conditions, you want to make sure that those are actually tied with a rational basis to a public purpose, and that the condition that you're giving actually carries out that public purpose. So those are two things that that you really need to be aware of, and I'll get to this a little bit further on in the Nexus test. But when you can't just say, well, we're going to approve this and we're going to add the condition that they have to paint the building pink when they're done, because what's the public purpose of that, right? And then to further that, even if there were a public purpose to that, does painting it pink achieve that public purpose? So there has to be those links in the chain have to be there if you're going to be approving something but putting conditions on it.
Yeah, and we can talk about an example on that with Anovo. I think you were there at that meeting. It was my first meeting, but Anovo
Oh
was a
God,
site.
what did I do? I don't remember.
No, you affirmed, in there, but Anovo, Brian was there, Anna was there at that time. Anovo was a use by right, and there was a situation there where there was a planning commissioner wanting to have a green roof on it for stormwater, but that's where it got a little sticky because we have a separate stormwater ordinance that gives authority of that review and issuing of those permits to the engineering department. So there was nothing in the record to say that, stormwater is not being mitigated, that there is a threat to the general health, safety, and welfare of the community that needs to be mitigated by this green roof. And so that's where, without that in the record, we're opening ourselves up to a lawsuit. You just can't ask for conditions because it's your preference, the pink house, the green roof. Now, if you want that and there is a legitimate government interest, public benefit by it, then codify it, put it in the ordinance. But you need to be predictable and not just making things up kind of as you go.
Right. Well, and two, just to add to that, there are instances like site plan review where if the conditions are met, it shall be granted. So, and we'll always, staff would always remind you of that and help you along. But there are certain instances where it can't be denied. If everything's been clearly met that's in the ordinance, it's not hide the peanut. You can't come up with something new on the fly for that particular development. It shall be met, and that comes from the Zoning Enabling Act. So they just basically tell us, if it's met, you have to grant it.
I have a question. So let's say the site plan requires some type of barrier. And I think the barrier under the ordinance could be a fence or hedge or whatever. And they bring their site plan and they haven't designated what it will be. It just says, we're going to put something there. Then has it been met? They said they're going to put something, but they haven't designated what it's going to be.
I think that's the instance where you would want to document in the record why. So if you wanted to say no, you would say it's not met, and the reason why is because there's no specificity, and, you put in the record, this is the reason why. And then you're more likely to win on appeal if it goes to appeal, because there's material evidence in the record that points to the decision.
And you do have latitude as well. Like, let's say they did specify that it's going to be a chain link fence, but you all feel that because of the land use next door, maybe a screening wall would be more appropriate because of nuisance issues. You can condition it to change, like, hey, we're going to go with this type of fence as part of the condition of approval. But again, let that be known in the body of record. That's the most key thing, is to have it documented either through motions or in staff reports and things like that.
Yeah, or maybe a better example would be, not a screening wall, but we're going to say, we're going to approve it, but we don't like your barrier because it has razor wire, and that's not safe. So the condition is that you have a plain old chain link fence and not a razor wire fence, because that's not safe for the squirrels and the children that are going to climb it, or whatever.
Because it goes back to the carrying out the public
The
purpose.
public, yep,
Yep. And
public purpose.
if the body determines that the application is incomplete in their mind, you can defer that, and you can say, hey, you haven't specified this, so we're not going to take action on it yet. There's not enough material here in the record, so please modify your documents and bring them back. And
That's absolutely
fine.
correct,
Yeah.
yep.
And I would encourage you to do that, as opposed to uncomfortably rushing something, like just cross the T's, dot the I's.
Okay.
I have a question. So like as a planning commissioner, can you be sued individually?
That's a great question. So the city indemnifies all of its staff and all the members of its boards and commissions and committees. So what that means is that to the extent that you're acting in your role as a planning commissioner or a member of staff, you would be covered in a lawsuit. I mean, sometimes people get named individually. It happens. Like what Sean said, you can't choose when you're going to get sued or who's going to sue you or how they're going to sue you, what they're going to say. So it could happen. But as long as you're acting within your role, your official duties and your capacity as a commissioner, the city would provide a lawyer to defend you and defend you through that lawsuit, and then pick up the tab, if for some unknown reason it was you got tagged with something at the end of the day and it was within your official capacity. So within your official capacity doesn't mean you're a planning commissioner and you go out and decide to like graffiti everything in the city and then you get tagged for it, and you didn't do that in your official capacity. You did that on your free time and you're on your own. So if it's in your duties, you know, example might be like, oh, somebody didn't agree, they said, oh, you guys all violated the Open Meetings Act. We're going to name all of you individually. And, you know, that wasn't so, but you're in this lawsuit. That would be in your official capacity.
And I'll just add too, because we have insurance coverage for the lawyers to defend in most cases. Otherwise, it's, you know, in-house counsel depending on what it is. But even if you're wrong, like your decision is ruled ultimately to be wrong, you still are defended. So it's not like, because otherwise who would ever serve, right? You're never going to get everything right according to a judge. So it's regardless of, you know, what the ruling was on your decision.
And your indemnification and counsel extends, you know, if your term ends and you're
Right.
no longer on the planning commission, but the action for which a lawsuit is brought occurred while you were on the commission, you're still covered by the city.
Yep.
You're not suddenly, you know.
We just cut you loose one,
Yeah.
like, thanks for your service.
lose your house.
Yeah, right. No, that's not
That's
so.
not gonna happen.
Yeah. Okay, just, I promise I'll wrap it up. So a couple more things. The reason that you can't just tag on some kind of unreasonable condition to the approval of some, you know, a permit or something like that is because it could be called an exaction. And really what that is sort of like a taking. Like, you can't say, okay, we'll approve your permit, but you got to give us an easement to get across your property, or you got to give us half your property so we could turn it into a park, or something like that, okay? You can do conditions. They have to have, like I said, that nexus, that connection, and they have to have a rough proportionality to what you are, the condition that you're putting on it has to be roughly proportional to what they're getting for their permit. So it's not an exact mathematical science, but it's just really that reasonableness test again. So don't go thinking, oh, well, we can, you know, we really always wanted that boardwalk down by the river, so you better give us an easement for that if you want to have your site plan for your building on the river, that kind of a thing.
I would agree.
And I think Ben touched on these a little bit, but sort of the authority of the Planning Commission is separate from the City Commission. Planning Commission, this is mostly all in the Planning Act, prepare and adopt the master plan, recommend the establishment of amendments to the zoning ordinance, site plan review, and then you review and recommend PUDs, SLUPs, things like that. City Commission, final decisions on enactment, amendment of the zoning ordinance. They're subject to state and federal law as well. They appoint planning commissioners, so that's one of the strings they've got attached to you. And then they have the final say on PUDs, SLUPs, things like that. One thing I just want to throw out there, because I think everyone takes their role really seriously and they're very focused on the planning aspect, but planning is not a panacea, right? There are a lot of other laws and regulations that regulate land use, like from the federal level on down, like Natural Resources and Environmental Protection Act, Construction Code, Land Division Act, Right to Farm Act, School Code, Fair Housing Act. There's all of these other things that work together. So I think in a really well-intended way, a lot of times it can seem overwhelming. Like we have to account for all of these different factors. We have to make sure that we're controlling all of these factors and make everything perfect, because otherwise it'll get out of control. Kind of like take the pressure off yourselves a little bit. There are a lot of other rules and regulations and laws that work together to help with that. And in addition to police powers that the city can enact as regular ordinances, you know, noise ordinance, other things like that. It's not all down to planning. Like, not everything is your responsibility and you're not going to get blamed for it. So, yeah, think about that sometimes when you've got a room full of people. And then also, just staff is your resource. I just want to reiterate that again. We're all here to help you. We have a lot of experience. I think staff in the city, without exception, is here for the right reasons. I've been here quite a long time, and I've really come to appreciate staff even more and more as as I go on. They're experts in their field. You can rely on them. You can ask them questions. They're going to help you. They want you to have the information that you need to make the decisions that you need to make. And so really lean on them if you ever feel like you need help. That's all I've got.
You, that was great.
Great. Thank you, Lauren. Any other questions for Lauren before we go ahead and move on? All right, so again, as I mentioned at the onset, we'll talk about some of these things that Lauren covered, but from a little different angle. So we're covering planning fundamentals as they relate to planning commissioners. So specifically, we'll be talking about your role in the planning process, the master plan, the zoning ordinance, and then land development options. Because some of these things are terms that you'll hear us mention that you won't deal with regularly. We might get a site plan review before the planning commission once a year. SLUPs maybe once every 5 years, PUDs every 10 years. You know, we could get 2 in 1 year, it varies, but most of this stuff is handled internally. So I want to make sure as we say these things that you know what we're talking about. And you don't have to memorize this when these opportunities come up. We will walk you through everything. We will also email you these PowerPoints and Lauren's outline and stuff once we clean some things up afterwards so you have them as reference. But just know that we're there and that there's, again, plenty of resources. So first, starting with the Planning Commission and your role as a planning commissioner, this was hit on a little bit, but your primary responsibilities are the development of our planning documents. The king of all of them, or the queen, is the master plan, because that is comprehensive. In fact, a lot of communities just refer to it as the comprehensive plan because it covers the whole community. But you may have other planning documents. Most recently, we went through the Mobility Action Plan as a sub-area or subtopic plan. We have the Corridors Master Plan. We have 2 whole, like 6-foot-tall bookshelves of plans in the city in our department right now. So there's a lot of plans out there, and it's really the Planning Commission's purview to focus on those land use plans. You have the role of establishing land use regulations to implement those plans, but as has been mentioned, you're a recommending body in a lot of instances to the City Commission. That's not to degrade the Planning Commission and their role in that whole network, because you have a very important role. You guys are the ones that do the heavy lifting, roll up the sleeves, do the research, review everything, and it's simply a matter of checks and balances, and that's why you make a recommendation to the City Commission, and that's all within the act, because that's the elected body representing people. And then you approve, or in some cases recommend, certain land development options. So some you directly approve, others you make your recommendation for. So one thing to understand, again, is your constituency is very comprehensive. It's not just the residents of the city of Traverse City. And this is true for the City Commission as well. Even though it's the residents that vote them in, you still represent all the property owners, whether that's a second homeowner, a business owner, the employees that need to come into town to work, tourists that visit our areas. It's really everyone that has any kind of activity within the city. That includes all lands, both the developed lands and natural lands. And it's important to remember that we're not an island, right? We play a part in the broader region. And just last week, we had a lunch with all the planners in the county, including Elmwood Township as well, to just kind of keep those conversations of regionalism going, because again, we're all stronger together than by ourselves. So again, most of your actions are recommendations to the legislative body for final approval. The key thing is that your decisions, as Lauren has hit on, needs to be rendered within your legal authority. So what do we mean about when we say legal authority? Well, your actions must comply with law. They can't be at odds with it. You can't exceed the authority enabled to you through the acts or local ordinances. It needs to be based on proper procedure, and it can't be arbitrary and capricious. So again, you can't just randomly make up a condition that a house needs to be pink just because that's the mood you're in that day or your personal favorite color. So keep that in mind. Our legal system in the state is chock full of zoning cases every year because there's limits to zoning, you know, and inevitably communities sometimes take it too far, and then it bumps up against constitutional rights and private property interests and things like that. So a lot of the umbrella of regulations in which we operate in really has stemmed from case law. So it's the court rulings that really figure a lot of this application out for us, and where that line is that has been crossed and where you need to avoid it. Yeah.
So that would be like recently the drone case that went all the way, I think, to the state Supreme Court. That then sets that case law for how communities can use drones for
surveillance, you know, because there's a lot in the Constitution about surveillance. So, you know, how are you using these local tools as well-intended as they may be, you know, those rights of individuals still remain. So,
Right.
yep.
And that case really got down to whether evidence should be excluded in a criminal case or in a zoning case, and for different reasons. So, I mean, it's pretty nuanced, what it can come down to.
And sometimes it's kind of funny, like, that was the Long Lake Township drone case, right? But when you talk to Leslie, who used to work there, she's like, well, you don't even think about that. But, you know, there's attorneys that see that as an opportunity. I don't mean this as a negative to attorneys, but it's like, hey, there's maybe a gap in the law. Let's bring this to trial to establish case law to fill that gap. And so, to my knowledge, you guys weren't super involved, like, at the end, correct?
And it wasn't standard practice, it was just gathering some evidence for a particular long-standing case.
All right, so just some considerations of your role, you know, as you sit here as a planning commissioner, is your work is forward focused, right? You're planning for the future. Now, with that, we know that change is inevitable, but the nice thing about planning is you can have your hand and be proactive in how that change occurs instead of just letting it happen organically. You can help move towards a more desired outcome with proper planning. So when you have those conversations of moving forward and things changing, we did this through the master plan, is it's worthwhile exercise to identify what aspects do we want preserved? What aspects do we like them as they are, but they could use some enhancement? And where are areas where a complete transformation may be necessary? You know, like an example, we used to have an iron foundry right downtown, right? That closed. That was a site that probably needed a complete transformation. Now it's River's Edge, home to Haggerty, apartments, restaurants, things like that. So again, we can only move forward from where we are. You know, nothing is permanent. The change is inevitable. We know that it's changing. We can't move back. We can't go back to where we once were. There's a number of reasons for that, right? Even if we could, you know, it's different people, different cultures, different values, different technology, different laws. You know, that which we loved in the past existed at that time. We're here in this time, and we're plotting our path forward. Now, the hard part is with the future is it's unknown. So you really just, you do your best, and sometimes failure comes out of it, right? But failure, we're afraid to fail a lot, but that was really hit at the Housing Summit this year. You know, failure's foolproof research on what works and what doesn't work. If you try something and it fails, you're like, okay, that didn't work. Now we can move on to something else. It's that process of elimination to getting towards your solutions. And iterations are key, right? You may put forward your best intentions and your best effort to get it all right, and then once regulations get implemented, it didn't really go as planned. You can amend, you can change. Nothing's ever permanent. If we look at ADUs, we've gone through the initial adoption of it and then 2 pretty significant iterations over a short period of time because people started realizing, okay, well, the outcome is not as intended. What do we need to do to change that? I think, Brian, you were probably around for a good part of the ADU discussions, and Anna for that matter too. So again, one thing that was also hit at our national planning conference that I would like to impart on you is, you know, one of the most important roles that you have as planning commissioners is to make sure that the voice of one group doesn't overshadow or silence the needs of other groups, right? Like we're often considered as a non-diverse community. And if you're going by the metric of race, that's probably true. But I think we are very diverse when you look at our demographics in terms of other aspects of it. And people have different needs, you know, and one group may be expressing their needs, and you may not be hearing the needs of another group. It might be in the data, but your job is to represent them too, not just voices that you hear at meetings, but really the community as a whole. And that goes back to that constituency that all of this is part of your purview. So with that, you know, change can be scary. We have to acknowledge that for people, for everyone. It's scary for ourselves in our personal lives because of the unknown, and it can represent loss for many people, but change can also represent opportunity. So much of what we love here today in Traverse City came as a result of change, very thoughtful, purposeful transformation. So just to kind of give you some insights, and I love old pictures of Traverse, we'll walk through a few right now. So, you know, back in the day, we were very much an industrial town, right? We had an industrial waterfront. It wasn't a place where people necessarily like to hang out. The kind of ironic part about some of this is most of us hate the Grandview Parkway where it is today, right? It separates downtown from the waterfront. Grandview Parkway used to not be there. When I listened to my predecessor give a presentation at the library, you know, it was actually the construction of Grandview Parkway that brought people's attention to the waterfront, because now they were down there, they were exposed to it, and they were able to envision a different future for our community. And that's when they started this 40-year process of reclaiming the waterfront for public use and recreation. So it is quite striking. If you were a number of decades ago standing on Union Street, this would be your view looking down there into the open space. It was the Morgan McCool canning facility right there. Very industrial town. Here you can see again from the air what is now the open space was very much a busy shipping dock. You have piles of coal there. You have a power plant. You see the storage tanks lined up along the bay. This is where we have a marina now today. So we changed the use of that land. And as you can see, there's not much opportunity for recreation. And I know our paralegal who grew up where Delamar is now, that used to be houses, like they were told as kids there was times where you're not allowed to go in the bay because of the canning facilities and all the chemicals they were dumping, and under no circumstance were they ever allowed to touch Boardman River as kids. So, you know, change has brought us to a new reality that I think we can all kind of be grateful for. And, you know, this is what Hall Street looked like, and around, this picture was dated about 1970. So to the right there is where you have Hotel Indigo, to the left is where you would have the candle factory, and to the front right now is where you have Lot RB. So again, change got us there. Here is the open space when it was quit being used as an active cold dock, but again, it sat there derelict for a long time. Quite a bit different than what we see today. And of course, it was anchored by the power plant that was down there. So in my lifetime, I remember that power plant. Most of you all do, right?
I
think we're
toured
all,
that.
Yeah, so I mean, it's recent history that this was part of our experience in Traverse City. But through those efforts, we were able to change to a design that now actually serves a greater public good. And I just want to point out that these changes, although we can look back now and say like, yeah, that was for the best instance, or for the best interest of the community, but these are always difficult conversations in a community, right? It's kind of funny now because we'll sit there and often hear about Brian Crow being accredited as this great visionary. When you talk to his partner at the time, like, he got beat up constantly for that vision, you know? So it's hard to go through these conversations, but people with conviction see through it and make it work. So this is our new marina. We reconstructed it. You can see all the industry along here has been removed. It's been brightened up. Now we have this gem that is photographed and displayed everywhere when promoting our region. And it's a place, again, more than ever for people, right? And that's a lot of what we do is this community is for people, so we need to make sure that we're serving the needs of them as best as possible. And so another example, and some of you may remember this used to be the entrance to the tunnel to Clinch Park, right? Now, if you weren't as able-bodied, if you had mobility issues and needed a wheelchair, or you were a parent with a child in a stroller, you could not use this safe crossing over in Grandview Parkway because it was just stairs. And if you remember being in there, it was dingy, it was damp, it was often flooded, it was pretty gross, but through change, we improved that connection for people. It's now ADA compliant. We have the heated sidewalks. The drainage has been taken care of. We've made it adequately light in there, which is part of that crime prevention through environmental design. We're able to showcase public art as well as the cultural heritage of the Anishinaabe people. So, and then some of my favorites are Front Street. So these are all like 1968 era. So if you look, it looks very tired, right? Facades aren't well improved. If you notice where the cars are parked and the width of the travel lanes, the sidewalks are much, much narrower than what we have there today. So clearly we can see where the prioritization was at that time, and that was for the vehicles and not people. I also don't see any trees anywhere in that building, right? Or in that streetscape, or many places where maybe people might sit, things like that. One thing I do see is a parking meter. So since 1968, we've been charging for parking downtown. So, you know, parking isn't free. Someone's got to pay for it.
Which block of Front?
That's
is
from looking across from what now Horizon Books is.
that?
Yeah, I always, and I forget what building this is, but these windows are very telling. So
The
yeah.
next set is, I just couldn't picture.
So this
that
is
one.
the
Yeah.
Playhouse, right?
Yeah.
So, and again, like, we talk,
Opera House.
sorry,
Opera
Opera
House.
House, I know, I'm not a thespian, I mess these up
Because
every
there's
time.
the camera shop.
Yep. And so it is kind of interesting too, because we've talked about this. When you look at the historic photos, downtown used to be built at a much higher density than what we have there today. So even right here, this is the corner of Union, this is the Masonic building. There was a fire here. This was a 5-story building, but after the fire, they only left the 2-story building. And so there was a lot of cases of that. Even the Hannah and Lay Mercantile building. If you look at it, I think it's 4 bays right now. It used to be 6, 2 of them burnt, so that density was lost in there as well. So here's another older picture that we had, the State Theater there. I don't know if you can see it from where you are, but I think it is funny that they're advertising that the movie is in color, because that wasn't the norm back then. Penny's is now Horizon Books, so many of these buildings stay. Here we have Plamondon's, very different looking. Ware's Brothers used to be downtown, so some of these older things. And then this is one of my favorites. This is J. Smith Walkway, where we have it today. So again, it was just kind of like this empty spot where a building had burnt down, and the city saw it as an opportunity to make a connection through there. But you contrast that with what we have today, which we only got from what you just saw to what we have now through change, and through those community conversations and stuff like that. So now we have.
We got rid of all the traffic.
Yes, we did. Yeah. Well, it's not COVID because it's not painted. It's probably super early in the morning.
It's
True.
So if you look at that streetscape now, we do have the trees. We have pedestrian scale lighting. We have benches. We have trash cans, we have bike racks, we have planters, we have bump outs, we have all these things. We have wider sidewalks now with the brick detail throughout them that we didn't have before, all of which contribute to a more inviting space. We have seen, and this is a pretty tried and true tale, when communities invest in themselves, then that's when you start seeing private investment as well. So as you invest in downtown, then that private investment started coming back. Our facades are really quite beautiful. There's a lot of pride in our downtown buildings and the appearance of them. And again, because of that, it's where people want to be. People like to be in these comfortable, welcoming, human scale spaces. So once was before very different and drab has now really been designed and catered to the people. So I think that's important to remember. And another thing that's interesting is, we talked about Grandview Parkway bringing interest to the waterfront. I don't know if people realize this, but M37, which Grandview Parkway is now, used to come down Rennie Hill Road, which is Veterans Drive, used to go down 14th Street. So if you've ever wondered why there's a state police post on 14th Street, because 14th Street used to be a state highway, so that's why it's located there. Then it came down Union Street, and then it turned and went down Front Street. So
back then,
as
it
much as
wasn't
we
37, it was Dixie Highway.
yeah, but as much as we hate where the highway is now, can you imagine how detrimental it would have been if the state didn't pull the highway out of downtown? Like, have you ever been to Charlevoix, where 131 goes right through there? They've tried their best, but it's always chocked full of traffic. More than likely, we would not have had the downtown preserve that we had today had they not constructed Grandview Parkway. So as much as we hate it, there's always the other
Might have
side of the
ended up
coin
like
to look at.
Kalkaska, where if you look, the west side has a nice 1 to 2 story building facade. The east side is basically completely bulldozed.
Yep. Now it's Railroad Square. They tried to activate it. So all of this conversation about change and stuff. So how do we get there? How do we actually implement change? Well, that all starts with the master plan. So this is the city's guiding document for land use that we all went through recently, so we don't need to spend a lot of time. As Lauren mentioned, again, you're allowed to have a master plan because of the Planning Enabling Act, and you are required to have a master plan if you're going to zone your community. So it guides all the land use and related systems in the city. It's required to have a 20-year timeline, if not longer. It is not a legal document. It is a decision-making document. So it's a decision-making document to help guide you in the policy-making discussions and questions that you're going to be faced with. But it is the Planning Commission's doctrine. And I say that because when you're faced with decisions, most of the time you have to set your personal preferences aside and say, what does the plan say? We follow the plan. That is supposed to be the intent of it. So you may recommend zoning regulations and other policy approaches, such as maybe police power ordinances, which you guys don't necessarily have the authority to adopt or anything like that, but you can make recommendations to the city commission regarding the city's police power ordinances or nuisance and licensing ordinances. But another key way of implementing the zoning is through partnerships. So a lot of times you'll see that in the master plan about the various partnerships needed, because again, none of us are as strong by ourselves as we are together. And we are required to review the master plan in 5 years, not required to update it, but at least go through a review. We do intend to update ours in 5 years, and it's been structured that way to keep that action plan relevant. So what are those elements of a master plan? Well, it's supposed to serve as a repository of community information, which is why we went through and made that supplemental portion, but we really beefed it up from what most plans allow, or cover rather. So really, we want to thank the City Commission for financially supporting that effort to put that report together, because we could have gotten by with less, but I think we're in a better position with that. Your plan has to include charts, maps, tables, and graphs. It needs a vision, guiding principles, your future land use map, so different future land use categories and descriptions of them and where they will occur throughout the city, a zoning plan. So that was new in 2006, or 2008 when they adopted the Planning Enabling Act. You need to have a section that makes a connection between your future land use categories on the map and your zoning designations or proposed zoning designations. So it's required because it serves as a tool to help you make those decisions. So we have that in the magazine portion, different sections of the city, and what some appropriate zoning would be. And then an action plan. So the various steps that you can take to implement that vision, the different actions. Typically what you'll see is a ranking of prioritization and who would be responsible and what partnerships would be needed to make that specific action a reality. So we have our future land use map. I think you've all looked at this. It's a little different than a zoning map. The categories are generalized locations where zoning follows parcel boundaries typically. So because of that generalization, the Planning Commission at times will have to make some interpretations and decisions on how to apply that. A good example that happened recently with this commission is the Ida Tompkins building across the street. The future land use category went right through the middle of that parcel. And so then you guys had to make that decision because, again, they're not following property lines, it's just generalized areas within the city. So this is, again, used as the basis for zoning, rezoning decisions when you get those before you. And we've talked about this before too. When it comes to implementing the future land use map and the master plan, you can take a reactive approach or a more proactive approach. And Mitch actually specifically brought that up when we were looking at the Third Coast Bakery. They wanted to conditionally rezone, and that's where it's like, well, we can wait till people ask us, but then we don't have much control in that outcome. Or we can go through and start rezoning consistent with the master plan to get the outcomes that we desire and are prescribed in the master plan. So again, those decisions are to be based on what the plan states. So again, this is really a document mostly for the Planning Commission, the City Commission, and really the other decision makers as they work on that, as opposed to the zoning ordinance. So the zoning ordinance is how you actually develop land. And unlike the master plan, which is a guiding document, the zoning ordinance is law. So it's adopted as an ordinance, it's considered local law, it has to be followed. So that is allowed and authorized through the Michigan Zoning Enabling Act. So those two pieces of legislation kind of work hand in hand, planning and zoning tend to. And as Lauren mentioned, zoning's been used to regulate land use for 100+ years in this country, starting in New York City, even though most of the originations were to deal with nuisance issues. They realized that if they created zones, they could be more proactive moving forward with where different uses would occur because they weren't always compatible. Industry was very, very dirty at that time. They were having a lot of issues with overcrowding in tenements, a lot of disease and stuff like that. So they came up with this idea of zoning. It was challenged and taken all the way to the Supreme Court in the 1920s in a case called Euclid v. Ambler, which came out of Ohio, and that's when the Supreme Court ruled that no, zoning is a legitimate government interest and has a public purpose, therefore it is lawful. So it's kind of been commonplace throughout the country since then. Because of that, you will sometimes hear us referred to as Euclidean zoning. Nothing to do with Euclidean geometry, but it's because that type of zoning that separates uses was affirmed by the Supreme Court because of the Euclid, Ohio case. So that's where that generates from. So the zoning ordinance does set the dimensional and use standards for the different land uses, and there's two main components. So there's the zoning map and the zoning text. So the map is the where, the text is the how and the what, to what can be developed there. So When we look at the zoning ordinance, zoning designation is not a promise, okay? Zoning is ever evolving, and I think that's hard for people to sometimes understand that, zoning is not locked into place. It changes as the community's needs change. In fact, the very act that gives you the authority to zone land right after that speaks to how you amend that zoning. So it's baked into the process. Now, we've had 3 distinct zoning ordinances in Traverse City. The first one was adopted in 1943, with the catalyst being largely Deering's on Union Street, because that was a butcher shop, and that use with the residential around it was creating a lot of conflicts, mostly with odors and things like that. So that's when the city's like, you know what, maybe we need to try to prevent these type of things, and we can separate some of these uses. Now, has planning taken it a little too far in some cases? Possibly, right? We've gotten away from more historical city patterns and divisions and things like that. So in 1958, the city adopted a whole new zoning ordinance. And so that map is on my wall in the office right now, and that was in place until 1999. So in just over 40 years, that map went through 200 map amendments. So that's about 5 rezonings a year, and they're all documented on that map. And you can see them, they're numbered, and you can see what year that they occurred and what the rezoning was. So I bring that up to the point that the rate of zoning amendments in the city's past was actually a lot faster than what we've been experiencing now. It's just right now we're seeing market forces really implement the zoning that has been in place, and that's creating a lot of change at a rate that many of us may be taking pause at. And so our current zoning ordinance was adopted 25 years ago in 1999 and has undergone probably a couple hundred amendments in that time period. Little tweaks here and there, all working towards achieving or implementing that master plan, or in some cases, like with the adult use marijuana, that kind of came down from the city commission, right? The city commission was going to allow this use, therefore we had a part in regulating where it could occur through the zoning ordinance. So the issue with that is successive edits that as you go through that amendment process, you start to get more errors baked into the zoning ordinance. Inevitably, you start to get inconsistencies, and occasionally we have brought in things to you as amendments just for housekeeping purposes when we find them, because that creates an interpretation issue for staff and planning commissioners as well. And to that point, it is occasionally worth completely rewriting the ordinance. That doesn't mean doing a full-scale transformation of all the regulations, but when you go through the practice of rewriting it, you start to find those inconsistencies, and you can structure it in a way that helps eliminate that in the future. So one key thing that we try to do is not repeat a standard multiple times. Say it once, and throughout the ordinance, keep pointing back to it. So if you do need to amend that, you amend it once and it applies everywhere. You don't overlook a section where we forgot it and now we have this inconsistency. So sometimes that need is precipitated by the master plan. Like sometimes you'll see that as a recommendation that, there's a good foundation here with the zoning ordinance, but because you've been essentially doing like a copy of a copy of a copy of a copy, there's errors, and rewriting it would help correct that and make it more predictable. So when we look at the zoning map, this establishes districts, because that's what the law requires, that you will group properties into districts, where within those districts you have similar uses allowed and dimensional standards. Therefore, you have a predictive, consistent development pattern. One thing that we will talk about in here at times is avoiding spot zoning. So you really should not do that. I'm not yet a municipal attorney that has not opposed spot zoning. It's just the law says you need districts of properties and things like that. So you wouldn't want to change one little residential parcel. That's not a district. That's getting away from the spirit of the act. So again, whenever you do a rezoning or changes to the zoning map, you need to be consistent with your future land use map. Now, if there's something that is in the city's best interest, in a location that would need a zoning change that is not consistent with the zoning map, there's a process for it, or the future land use map, there's a process for that as well. You can amend the master plan, right? You can go through a public process and get public input on what is being proposed. So that's what I would recommend you do in that situation is don't just try to make the zoning work. Start from the beginning, address it in the master plan, amend it, put the zoning regulations in place, and then discuss the merits of the project. So again, if you're doing a rezoning, it's important to note that a rezoning can be initiated by any member of the public through an application. That's what's important. Someone standing at a podium saying you should change the zoning of this is not going to trigger any action or formal review. That only starts once an application is on record. It can also be initiated by the Planning Commission. The City Commission, as a legislative body, can initiate zoning amendments. They'll send them to you to review and make a recommendation back, or by staff. So again, review that under the prescriptions of the future land use map. So if you were rezoning, say, this parcel here, I don't think my cursor shows up on those screens, but that bump out into Boardman Lake, you would look at what the existing zoning is, look at the future land use map, figure out what that category is, look at the zoning plan and the master plan to say, okay, that future land use category would most appropriately be A, B, C, or D in the zoning district, see which one makes the most sense there, and then make your recommendation. Now, sometimes you may find it necessary to couple a map amendment with the text amendment. So an example of that was along 8th Street. So on the south side, south side, you had D2. On the north side, you had a combination of C1 and C2. So following the Envision 8th Street plan, they rezoned the north side of the street to D2, but recognizing that that would put the commercial properties in zoning designation right up against residential, the Planning Commission not only rezoned on the map, but they changed the contents within the D2 district to be a better fit. So that was kind of like a 2-for-1, where it was a map amendment with a text amendment component. So another type of zoning or rezoning is called a conditional rezoning. I absolutely hate these. They're kind of an administrative nightmare to follow, but they effectively become a change in a zoning district. So these are allowed in the Zoning Enabling Act. You're not required to make it an option, but it is in our ordinance. So in this case, an applicant may request to rezone their property while voluntarily limiting either the use of that property. So let's say they're going from C1 to C4. They're going to say, hey, we're really going to just pare it back to just these uses in C4. We're not really interested in all these other ones. Or let's say C4, in this example, will allow you to go from 35 feet to 60 feet. They may say, hey, we're only going to build the 45. So these are things that they can provide in their application. What makes these a little tough is you have to take them at face value. There's no negotiating with a conditional rezoning. There's no adding conditions to the approval. It's either a thumbs up or thumbs down. Now, our role as staff is to maybe, as they're working on their application, impart to them what the master plan might say and inform the applicant, but you know, there's really not much that you can require from them. Now, through the conversations that you have, they can modify their application at any point until City Commission action. And so that happens a little bit. Those of us that were around for the Third Coast Bakery conditional rezoning, he did that a few times. He heard some things and he kept modifying, but it was never required as a condition of approval. And that's what's key in that case. But even those get sent to the City Commission for final approval. Again, they can be misused because sometimes people see it as a way to skirt around the zoning and kind of get what they want. So you have to be a little mindful about that. And so an example that we have right up here is TC Lofts. So TC Lofts could be 45 feet, but they were conditionally rezoned to C4B, which would allow 60 feet so that they could build this community room up top, but they volunteered the condition that would be used only for that purpose. All right, so they can't turn it into apartments or a restaurant or anything like that that the C4B would otherwise allow, because that's been memorialized in the approval and the agreement. And that travels with the land. So if the owners sell the property, those conditions and everything still exist.
The one thing I would say, because I live in that building, of course I have to say it, is if you don't have good counsel, if you don't have good access to an attorney, or don't feel comfortable speaking to staff, you can end up in a situation where you have conditionally rezoned yourself into a hole. The community space that we have on our roof is only like 2/3 of the roof. There is an entire side of the roof, the south-facing side, that was not part of their proposal because they were just trying to get the community space open and accessible to residents, that they didn't consider that part. They thought they could do it later, and it is now wasted space. It is literally storage. It is unfinished storage because they cannot build on it. And it's really sad. It could be 3 additional units. It could be a community gym. So that is something that is unfortunate. That's all.
No, I mean, that's a good point, though. Sometimes, you know, we can perceive that voluntary restricting some of those uses as a protection measure, for sure, but it then binds the property to just that. It doesn't allow it to necessarily evolve to meet the evolving needs. And that's where, again, it can be a bit of that administrative nightmare to kind of constantly keep working with that. And then to make a change to that, you basically go through a rezoning again. So it's that whole process and stuff like that. So, all right, so now moving on to the zoning ordinance, the text component. This is really all the verbal detail, not just the visual, where things go, but all of that. It's where you'll find your dimensional and use standards. So this will be the uses that are allowed in each district, keeping in mind that zoning is permissive, meaning you can only do what the zoning says you can do. Because if zoning listed everything you couldn't do, ordinances would be 4 feet thick. So it focuses just on what you're allowed. This is where you're going to find your setbacks, your height, your lot coverage, as well as elements that have been identified as necessary for mitigating nuisance issues such as screening walls, hours of operation, exterior lighting, things like that. Language is super important in there, so interpreting that language and making it clear helps everyone understand it. You know, zoning delineates between where it says may and where it says shall. Those are 2 very different words and have different meanings to them when it comes to this. And the definitions really matter too. So when I used to write zoning ordinances as a consultant, the thickest chapter in every ordinance I wrote would be the definitions chapter, because that's kind of coverage for you. You know, you can always go back and say, well, no, it says it's this. The more you have defined, the less wiggle room for interpretation and challenge you're going to face throughout that. So one thing that is nice in the ordinance is allowing those reasonable exceptions that we have. So it allows, you know, projects to keep moving forward. The problem with zoning sometimes is the standards apply to every property equally, but we know every property is different, has a different context. So sometimes having slight exceptions in there helps with just letting these projects materialize. But of course, decisions and interpretations and all that can typically be appealed to the BZA. One thing I will point out, though, is there seems to be this default. If you tell people you can't do that because zoning doesn't allow it, they're like, well, I'm just going to get a variance. I'm going to go to the BZA and get a variance. There's actually a pretty high threshold for getting a variance, and just simply asking for it because you want it is not it. You know, there's a multi-part test to issuing a variance, because if you want to allow that, then put it in the ordinance. That's the way to do it, right? Okay, so how do we do a zoning ordinance text amendment? Again, this could be initiated just like a zoning designation or zoning classification amendment through an application by the public. It can be by the planning commission, city commission, or staff. This is probably what this commission is most engaged in on an ongoing effort, is the text regulations as they apply to the development of land and how we try to get that land to meet the needs of the community. These do require public hearings and proper notices. Now, in some of these instances, like a rezoning where what we're talking about is dealing with a specific subject property, you're required to mail every property owner and occupant within 300 feet that notice 15 days prior to the meeting. We stick to 300 feet typically, all right? Some people will say, well, maybe you should go farther. Most attorneys will say, stick to what the law says, otherwise you can find yourself in legal trouble. Because if the law says to go 300 feet and I go 1,000 feet, a challenge could be brought to me that I tried to stack the deck against the developer by doing that. And so those are the things that we try to avoid, and we just try to be consistent with everyone as we do these processes. And of course, those text amendments, like map amendments, go to the city commission for final approval. All right, last thing that I'm gonna whip through here kind of quick are your different land development options or different types of approvals. So approvals occur really in 3 broad categories: either administrative approvals, which are done by staff in the city, the planning commission, or the city commission. So in some cases, you can approve things directly. In other cases, you make that recommendation. So I want to point out that projects that trigger our city's stormwater ordinance, so commercial properties, anything with 3 or more dwelling units. These also go to our internal staff design team, which is something that we've been working with for about a year. We meet weekly, and this has really provided a benefit for us because, as I'll go through here in a little bit, there's a lot of permits you need from different departments in the city to build in the city. And it works best when we all sit and look at the plans together and provide our different perspectives, because from planning and zoning, we might say, hey, you know what, you need to move this accessory building here to option A, B, or C to meet the zoning requirements. Well, the fire chief might say, well, if you put it in A, you're not going to meet the separation standards. And the utility director might say, well, if you put it at location C, you're going to be building over a water main. That's not going to be allowed. So this is how we work together to make sure all the standards are met within a project. And so that's going to be something that we require before issuing our land use permit, also referred to as a zoning permit. Basically what that says is what's being proposed is compliant with the zoning. As Lauren mentioned, approvals typically can be approved with conditions, or denied. And that goes for staff too. Like when we approve land use permits, we sometimes have to attach conditions as well. But again, those conditions cannot be arbitrary and capricious. So you might hear the term use by right. So this is a use that is allowed in a zoning district, really has no additional special approvals typically with it. It's consistent with the intent of that district. The standards are non-discretionary, meaning they're objective. They're either met or they're not met. And as Lauren had went over, if it's a use by right and all the standards are met, you shall approve. You can't deny them that. In other words, you've put the rules to the game in the ordinance. They played by the rules, they get their permit. And because of this, that's why most uses by right are just simply approved by staff. It doesn't mean that the standards aren't given the same scrutiny. We stand around a big table oftentimes talking about them, taking things to the design team and working through it. So site plan review is a variation of a use by right. So that's specifically when it's a use by right that comes to the Planning Commission for approval. And these are uses that generate over 500 trip ends a day. So that is, if you live at your house and you leave to run an errand and you come back, that's 2 trip ends. So every time someone comes or goes is a trip. So what this is basically saying is, by acknowledging the threshold of 500 trip ends, that certain uses by right have a higher intensity and therefore will take another layer of approval. So you still review the district and use standards, which are discretionary. There are additional site plan approval standards, but when you read through them, they are also, I'm sorry, I think that's supposed to be non-discretionary. Non-discretionary, they're objective. They're pretty black and white. You know, it's like, is the mechanical equipment on the roof or on the ground? Pretty straightforward stuff. But again, what's going to be important here is establishing that finding of fact. So when I say finding of fact, that is the material competent record that Lauren was talking about. So whenever these are presented to you, we will generate a staff report. We will provide an overview of the property. We will show you its zoning designation, its future land use, what the master plan says about it, what all applicable zoning standards are. We will comment whether or not they've been met, and then all the site plan review standards in the same. That serves as your body of record. So when you go through this, the motion will typically say to approve, and adopt the staff report as the finding of fact. So that's put into the record, and it's identified that this is serving that purpose. Now, what we present to you as the staff report is completely modifiable. So if you disagree with staff, change it. That's your right, your role, your responsibility. So we want to give you a starting point to work with. So the process is we receive an application. We really don't do much until that happens. Staff reviews it, generates a report. It goes to the Planning Commission for your review and decision. So this is one where the decision stops with you. Once that decision is made, we can issue them a land use permit. We review everything again when we issue that land use permit, including whether or not the conditions that may have been applied by the Planning Commission have been met. Once they have their zoning permit to say, yes, this use is compliant with zoning, then they can start to get their other permits. So that would likely be a right-of-way permit, a utility permit, a fire permit, a stormwater permit, all these various permits that have their own standards and reviews and things like that. Once that's done, then they can go to the county and get the construction or the building permit. And so that oversees the structural and mechanical components of it. And I didn't put it in here, but again, to Lauren's point, they might need an Army Corps of Engineers permit or a Eagle permit or something like that. That's not our jurisdiction, so we don't issue those, but that's part of that applicant's process potentially. Only then can they start construction. So it's not uncommon for approval to take a very long time going through this. And I highlight that just to note that there are so many checks and balances and reviews throughout this process. All right, next, special land use permits. We do not get these very often. These are uses that by their nature require a higher degree of review and scrutiny. So in addition to those discretionary standards, every special land use permit use also has a set of general SLUP standards that apply to all SLUP uses that have to be reviewed. Those get put into the staff report as that body of record. And then for each one, we have use-specific SLUP standards that are tied specifically to that use. Those all have to be reviewed. The SLUP standards are the ones that you may find to be a little more subjective. This is one of the few cases where the Planning Commission can really make judgment calls, and that's where you want to rely heavily on your master plan and think about the impact of the use on the neighboring properties and the city as a whole. SLUPs by law also require a site plan, so they can't just tell you what they're going to do, they have to show you. So the site plan review is part of the SLUP process in that case. And like I said, we will generate that report as your starting point. There's two types. There's the administrative SLUP and a city commission SLUP, the latter being the more thorough one. So when you look at the SLUP uses, those that are less intense tend to be administrative. The more intense ones tend to be city commission SLUPs. Both require a public hearing as well as the mailing within 300 feet, and I will always say you must establish a finding of fact. So my little arrows got messed up here, and this version of Microsoft does not let me edit PowerPoint, so I wasn't able to change it on this, but we'll receive an application. That starts the process. We generate the staff review and report. The Planning Commission by law has to hold a public hearing. After that, only after that, can you make your recommendation to the City Commission. Then the arrows should jump over here, sorry. Then the City Commission, by local law, our ordinance, also has to hold a public hearing. State law doesn't require that. State law doesn't even require it go to the City Commission. Some communities, the final decision's made at the Planning Commission level. Once they have held their public hearing, they will make their decision, again, approve with conditions, or deny. And then we generate what's called an order granting, which is a legal document, is that safe to say, that really memorializes everything that is going to be done, what conditions may have been there, any other contingencies. In the case of, say, Safe Harbor, there was the operating agreement that was kind of memorialized in there. So that's the permanent record, and that gets filed with the Register of Deeds, I believe, potentially.
I don't remember if the
Yeah.
order granting does.
Some communities require that to be recorded at the Register of Deeds because it stays with the land, all right? If someone buys that land, that SLUP still defines how that land is developed and used. Now, there is opportunities to rescind SLUPs. That's a process that we have gone through before. So again, once the order granting is executed, land use permit, other city permits, then they can get their building permits, then they can get to construction. So again, definitely a multi-month process, especially with the public hearing notices that are required in the 15-day timelines. And the last one I'm going to talk to you about is planned unit developments. These essentially create a zoning ordinance for a specific project. So PUDs do allow you to deviate from the base zoning standards, but only to the extent approved and allowed through that approval. So they can't just do whatever they want. They have to itemize and kind of tell you what they want to do different. So the last PUD that we had was for the senior center, if you recall. And the reason that was a PUD is they needed some flexibility in where the parking was going to be located, because it's not supposed to be street side of a building, but we didn't want it water side, so that was one way to do that. And I think the building itself was larger than what the OS district would allow. So this, again, it was approved to be that way, and this is a legal process in the Zoning Enabling Act to allow you to do that. But if you go back and look at that staff report, that approval in the motion specifies in what ways they're deviating from the base zoning. So they can operate within that base zoning, and then what exceptions have been allowed through that approval. Now, this can be done in one phase. It can be done in multiple phases. From my experience, a lot of times the multiple phase PUDs end up being a disaster. If anyone wants, well, I won't say that. There's some that we've been dealing with 20 years and multiple lawsuits and stuff like that, because you have to define at this point in time how that land is basically going to be used in perpetuity. Well, as conditions change, that PUD approval locks you in unless you come back and go through that amendment process, which many of you on this commission may have experienced with Morgan Farms, because they've had a ton of amendments over the years as market demands change and things like that. So just keep that in mind. That's something that might happen. Usually with a PUD, if someone is asking for some sort of exception to the base zoning, there usually is some sort of public benefit associated with that. So I'll give you an example. In a different community, I was working in Acme Township, and they were willing, when they wanted to do a PUD for the Kmart Tom's complex, and the applicant was willing to provide an easement for a planned trail through the property, and that was part of the public benefit that they were willing to provide in order to get what they wanted. I mean, ultimately, that PUD didn't get approved because the only guarantee he would make is the use that wasn't allowed in the district. So he wasn't going to do any of the housing as a guarantee, and so the Planning Commission ultimately felt like it was being abused, the PUD, as a way to skirt the zoning requirements rather than using it as a way to benefit both parties. So when it comes to the PUDs, I would probably be working a lot with Lauren on that fine line between an exaction and a negotiated agreement. You know, we can't force them to do something, but you know, they know they're asking for something, and so usually they expect to have something asked of them back. And so that's where kind of that public benefit comes into play. So you will have a PUD coming to you soon. We did receive the application for the TC Millwork site, which they came and asked you to make a recommendation to the City Commission, which was ultimately approved to do a PUD on a property less than 3 acres. And as we talked about then, that was one of those unique situations. That property is heavily encumbered. And so the PUD is going to give both parties, the Planning Commission and the applicant, that flexibility to come up with a great project at that location. Yeah, any questions on PUDs? I'm pretty much done with those. A couple other examples that we have in the city. I think River's Edge was a PUD. Fairway Hills, which is a development off of 17th Street by Cass, that's a PUD. Bayshore Resort next to the Senior Center, that was a PUD. We don't have many in the city, so. All right, so the PUD process, it's pretty much the same as the SLUP process. So you're gonna go through the review once the application is submitted and the generation of the report, Planning Commission public hearing and recommendation, City Commission public hearing and decision, execution of the order granting, land use permit, other city permits, building permit, and then construction. Now, with all these things that we've talked about so far today, I didn't get into it, but there are ways to amend those approvals. There's minor amendments, which are typically granted to staff to determine, and it spells out what those are and the extent of it, and there's limits to it. Major amendments oftentimes mean going through the original process again. So that would mean public hearing if one was required, City Commission recommendation, things like that. But we bake that into the system to help people and just acknowledge the fact that conditions change over time. So with that, that's all we got. So I just want to thank Benjamin and Lauren for joining us today, and you all for being a captive and participating audience. So.
Well done. Does anybody have any questions for any of our presenters or comments? I guess, wow, we're overwhelmed.
Stunned silence.
Stunned. It was a lot of information.
I know, your brains
it's
are probably
great.
tired
But
again.
it's
We'll
great.
send it to you as resources.
Please
We're here
do.
as resources.
Does the
You don't have to
public-
navigate it on your own. So.
Does the public have any comments about what you heard tonight? All right. Well, with that, I think we are adjourned.
All right.
Thank you, everyone. That was really great.
Yes, thank you.
I felt like I was back in law school, Lauren.
Don't say law school to Lauren.
You were in law school?
Huh?
You were in law school?
She's
I was a lawyer for 9 years.